Good evening, everyone, once again. Thank you so much for joining us this evening as we take a relook at Novartis versus Union of India. It is a judgment that was decided almost 10 years ago that permanently altered the intellectual property landscape and patent law in India as we knew it then. Not only do we have special attendees with us this evening, we are also live streaming this event for the benefit of a larger audience in India and abroad. With us, we have Honorable Justice S. Ravindra Bhatt, Honorable Judge of the Supreme Court of India, Professor Dr. G.S. Bajpai, the Vice Chancellor of National Law University, Delhi, and Dr. Yogesh Pai, Associate Professor of Law at National Law University, Delhi, on the stage. Before we commence with the session, I would like to request Professor Dr. G.S. Bajpai to please felicitate Honorable Justice S. Ravindra Bhatt with a bouquet as a token of our gratitude. Thank you so much, sir. I now request Dr. Yogesh Pai to please felicitate Professor Dr. G.S. Bajpai, Vice Chancellor of NLU Delhi, and welcome him with a bouquet. Thank you, sir. We now begin with the inaugural session with the welcome remarks by Professor Dr. G.S. Bajpai, the Vice Chancellor of NLU Delhi. Professor Bajpai has recently assumed charge as Vice Chancellor of NLU Delhi. Under his mentorship, NLU Delhi aims to build on the academic traditions and the research ethos for which the university is renowned. And we're sure that under his aegis, NLU Delhi will soon emerge as one of the leading global centers of innovative legal research, not only in India, but also abroad. Thank you so much, sir, for joining us today. And I request you to kindly inaugurate the session with the welcome remarks.
Very good evening to all present, and I welcome you all to this August gathering to mark the 10th anniversary of the groundbreaking Supreme Court decision in the area of intellectual property, that is Novartis versus Union of India. Decided on 1st of April 2013, this decision of the Supreme Court of India has been highly debated, not only in India, but also abroad, due to its impact of innovation incentive for R&D pharmaceutical industry and how it provides an ecosystem for India's generic companies for early generic entry and thereby enable access to medicine. As an academic institution of excellence, National Law University Delhi has always positively engaged in the teaching and research in law, including socioeconomic dimension. It is in this spirit that the Center for Innovation, Intellectual Property and Competition and IPR chair at NLU Delhi, established by DPIIT, Ministry of Commerce and Industry, is organizing this symposium on 10 years of Novartis versus Union of India. The center and the IP chair have always strived together, achieving higher levels of academic consciousness by providing high quality education, training, and research. We are so honored to have Honorable Mr. Justice Ravindra Bhatt, Honorable Judge of the Supreme Court of India, here today to deliver the keynote address. As a visitor to the National Law University Delhi, we have a wonderful patron in him. Justice Bhatt needs no introduction to the legal and particularly the IP world. His decisions have had great significance as it has always dealt with some of the most complex aspects of facts and law in the context of intellectual property, which are a high presidential value. Honorable Sir, I welcome you to this symposium, and we thank you for accepting our invitation to this symposium today. This symposium brings together a panel of eminent experts in the field of intellectual property. Our panelists, although directly involved in these issues, have an academic mind, which is the reason why they have kindly agreed to be the part of this gathering. I welcome Mr. Hemant Singh, Dr. Malati Lakshmakumaran, Mr. Guruswamy Natraj, and Professor Brian I understand that Professor Mercurio couldn't travel due to his some exigencies, and he will be joining the panel online today. With us also have Ms. Jayashree Vatal, visiting professor at NLU Delhi, to moderate this esteemed panel. So I welcome you all to this symposium and look forward to the wonderful discussion. I'm also told that who's who of the IP world in here today with us. We have attendees from not only the top law firms and IP practitioners, senior patrons, and litigators, but also have trade and IP representatives from embassies of different countries, representatives of industry organization, and pharmaceutical companies. Most importantly, we have senior academics and academically minded practitioners in the area of IP. I welcome you all to this symposium. I'm sure your views and comments during the floor discussion will be enriching and add great value to the symposium and panel discussion. Although due to space constraints, we could not invite many who we thought to be interested in this symposium, particularly from among the student community and people located far and wide across the globe. We have made it a point to live stream this event on our university's YouTube channel. And I'm sure that folks interested in this topic across different parts in India and the world will find it immensely useful. However, we do have a small group of students from NLU Delhi who are studying a specialized course on IP, jointly offered by Dr. Jayashree and Dr. Yogesh, whom we thought would benefit immensely. So let me take this opportunity again to welcome you all, particularly those who have joined us live from different parts of India and from across the globe. The recording of this symposium will be available for all times to come, and I'm sure that all will be benefited from this initiative. Finally, I'm appreciative of the efforts of CIIPC and IPR chair at NLU Delhi for having organized this symposium, particularly when India is negotiating several free trade agreements where issues around IP are bound to cause some amount of debate. However, as an academic community, we always look forward to providing and conducting a nuanced and informative dialogue on issues such as these. I welcome you all again and thank you for joining this event today. Thank you, Ananda.
Thank you, sir, for your warm welcome and words of encouragement. Honorable Justice S. Ravindra Bhatt needs no introduction. However, in the interest of the wider audience in India and abroad, I'll briefly read out an introduction. Justice Ravindra Bhatt practiced before the Delhi High Court and the Supreme Court of India for more than 2 decades before serving as Honorable Judge of the Delhi High Court and Honorable Chief Justice of the Rajasthan High Court. He was elevated as an Honorable Judge of the Supreme Court in September of 2019. Over the last 2 decades, Justice Bhatt has penned many landmark judgments in several different areas of law, including intellectual property laws, drug regulation, and RTI. Roche versus Cipla was one of the first pharmaceutical patent infringement cases in India, wherein, going against the entrenched norm of routinely awarding interim injunction in such matters, Justice Bhatt refused injunction on grounds of public interest. Bayer versus Union of India and CPIO versus Subhash Chandra Agrawal are only few among the plethora of significant judgments pronounced by Justice Ravindra Bhatt. It is truly an honor to have Sir with us as we discuss another landmark judgment in the field of intellectual property. I would now like to request Honorable Justice S. Ravindra Bhatt, Honorable Judge of the Supreme Court of India, to kindly grace the occasion with the keynote address.
Sir Pai requested me to speak on Novartis. I think I remarked to him that I'm very much out of touch with intellectual property. Professor Bajpai, Vice Chancellor, NLU Delhi, Professor Yogesh Pai, Dr. Malti Lakshmi Kumaran, Mr. Hemant Singh, Mr. Guruswami Natraj, Professor Brian Mercurio, Ms. Jayashree Wattle, faculty members, academics, students, ladies and gentlemen. Many of you might have heard of Myriad Genetics, the judgment of the US Supreme Court in 2013, which dealt with the patentability of genetic, that is DNA strands. We had our own Myriad moment in Novartis, so to say, because I think the earliest judgment or the only other judgment, which I don't remember the cause title, which our Supreme Court had dealt with was 40 years earlier, perhaps. Yes, Vishwanath Raj. So with the entry of the product patents regime for pharmaceuticals in 2005, and Section 3D with its explanation was introduced in its current form, in disposing pre-grant oppositions filed by generic companies, NGOs, and cancer patient groups, the Patent Office rejected the Novartis patent application for the beta crystalline form of imitinib in 2006, citing Section 3D, as well as on grounds of lack of novelty, inventive step, and for claiming wrongful priority. Novartis filed a writ petition, of course, on another topic altogether, which was untenable, of course, that 3D violated WTO. That was rejected. Novartis also unsuccessfully filed an appeal to the IPAB on merits of the rejection of its application. It thereafter appealed to the Supreme Court. The IPAB had held that Section 3D excludes patent eligibility of new forms such as the beta crystalline form unless enhanced therapeutic efficacy is proved. Novartis claimed that the beta crystalline form offered increased thermostability, was less hygroscopic, and had advantageous free flow properties, and further claimed that the drug was 30% more bioavailable. The Supreme Court of India, in affirming the rejection by the Patent Office, noted that Section 3D was introduced in its present form to deal with pharmaceuticals, and that it clearly sets up a second tier for patentability after novelty. The court interpreted the term efficacy as ability to produce a desired or intended result, and held that the test of efficacy would depend upon the intended result of the product under consideration. In a case of medicine which cures a disease, the test of efficacy is therapeutic efficacy, and parameters of therapeutic efficacy should receive a narrow and strict interpretation. The court did not define therapeutic efficacy, but used the explanation to Section 3D to describe what it does not cover. It held that A, not all advantageous or beneficial properties are relevant, but only those which directly relate to efficacy, and that mere change of form with properties inherent in that form would not qualify as enhancement of efficacy. On the question whether an increase in bioavailability leads to an enhancement of therapeutic efficacy, the court held that such enhancements must be specifically claimed and established by research data. Now, Section 21JA defines pharmaceutical substance as any new entity involving one or more inventive steps. Therefore, it is clear that when a new form of an active ingredient or new chemical entity, NCE, mentioned in explanation to Section 3D is covered in a patent application, it should show the details of enhanced therapeutic efficacy. Therefore, the first issue would be the burden or the onus of proving it. Because if it forms part of the same class of an existing substance, then it is deemed to be part of it. Interestingly, I came across an article by Prashant Reddy, another academic, who explained that Section 3D had its roots in the supplementary protection certificates of the European Union's conditions, whose explanatory statement said that the proposal for a regulation therefore concerns only new medicinal products. It does not involve granting a certificate for medicinal products that are authorized to be placed in the market. Only one certificate may be granted for any one product, a product being understood to mean an active substance in the strict sense. Minor changes to the medicinal product, such as a new dose the use of a different salt or ester or a different pharmaceutical form will not lead to the issue of a new certificate. This, he said, is the genesis of Section 3D. It has been 10 years since the judgment in Novartis. You're all aware that Article 27(1) of TRIPS obliges WTO members to make available patent protection to all inventions in all fields of technology. That article, apart from spelling out the criterion of patent eligibility, also offers some flexibility, as it does not define the parameters of novelty, inventiveness in industrial application, thus giving members the scope to determine the criteria of how these should be interpreted and applied. The types of innovations in the pharmaceutical sector may be classified as major and minor. New molecules are rare, yet thousands of pharmaceutical products patents are granted each year, which raises the number of concerns, raises a number of concerns as to the number of patents that may be granted for minor modifications. As is evident, the bulk of such minor modifications would be based on merely the new use of a known pharma product. The TRIPS agreement itself does not prevent countries from denying patentability of new uses for lack of novelty, inventive step, or industrial application. In the case of new users, countries are free to decide whether or not to allow their claims. Applying the formulation of 3D, the Supreme Court observed that the Novartis application was hit by Section 3D, as it was a salt form of imatinib and was a known substance based on an assessment of the prior art. The causal nexus between enhanced bioavailability and enhanced therapeutic efficacy was not established as required by the explanation. It also held that the beta crystalline form, as I said earlier, lacked the inventive step. So where does it lead us? The guidance that we have from Novartis is that the efficacy of beta crystalline form of the chemical entity was not sufficient to establish efficacy. Quantitatively, that is taken in, such as, for instance, the therapeutic efficacy or efficiency in terms of longevity of the patient in case of life-saving drugs. The question would be how long? Does this also result in increased efficacy? In the case of an NCE claiming greater relief, for instance, in regard to painful effects or eliminating side effects, or where efficacy is in terms of fewer doses, what is the tipping point? So these are all matters which I think would unfold in the cases to come. The issue of efficacy is a loaded term that warrants further evaluation, as a series of questions can be raised. What are some of the ways to construct benchmarks to measure efficacy for new inventions? Could there be a robust way of measuring efficacy? Section 3D is not limited to pharmacology. What would be the standard for other patents, especially chemical? We are talking of, it could be pesticides, etc. Does reduction of a side effect be construed as satisfying the heightened standard? What are the characteristics, advantages, and benefits that can be brought forward for a substantive determination of the enhancement of therapeutic efficacy? This still leaves open the issue of its appropriate measurement for consistent application to determine patentability for a wide-ranging product type. So with this, I think I will not take further time. You have I think 3 panels and a list of eminent speakers and practitioners. So I wish this meet all success. And I hope this after the COVID pandemic, we are all meeting for the first time, perhaps physically. Let us hope that this ushers in a new era where people meet and discuss these. And also, I would urge that we should look at these things empirically and compare in terms of data which is available through the patent office. As to, there is data, there are articles, but I think there is to be a greater need to be, need for research as to the number of rejections which have taken place and how far is this Section 3D serving us 10 years down the line after Novartis? And are things taking shape? Because some judgments have come in the Delhi High Court, and perhaps a couple of judgments in Madras High Court, and maybe the erstwhile IPAB has also given some orders. Again, straying from the topic, I think the abolition of IPAB was a very regrettable step. It was developing extremely good jurisprudence, and its establishment was in consonance with the WTO mandate of having administrative remedies. So I will not take any further time except to say that I'm delighted to have been invited, and I wish this meet all success. Thank you.
Thank you, sir, for your illuminating remarks that will guide us throughout the course of the event. I would like to request Professor Dr. G.S. Bajpai, Vice Chancellor of NLU Delhi, to felicitate Honorable Justice S. Ravindra Bhatt, Honorable Judge of Supreme Court of India, with a memento as a token of our gratitude. Thank you, sir. I would now like to request Dr. Yogesh Pai, Associate Professor of Law at National Law University, Delhi, to kindly enlighten us with an introduction and background of the case.
Thank you, Sanika. Honorable Justice Ravindra Bhatt, Honorable Judge, Supreme Court of India, beloved Vice Chancellor Professor G.S. Bajpai, esteemed panelists, and all of you. I, again, on my own behalf, welcome you. I wanted to do a brief introduction to the case, but I think Justice Bhatt has done a lot of justice to the dispute. And I would not further, delve into the legal nuances, but for the benefit of those who are not well-versed with the legal dimensions of this case, I'll briefly explain the, kind of other facts surrounding the dispute. Now, if you all know, Section 3D was reintroduced into the Indian patent law with an explanation which, had words such as enhancement of efficacy. And the word also used as known substance. Now, if you look through what happened in this dispute, it goes back to 1993 when Zimmerman, who was the inventor in this patent, there were several initial patents on imatinib, which is a free-base compound that was filed for patents, not in India, because India did not have a product patent regime between 1972, because the Patents Act 1970 was implemented in 72 till 2005. And because there was no product patent regime in India, this initial free-base molecule patent on imatinib was not filed. But subsequently, during the TRIPS transition period between 1995 and 2005, an application was filed by Novartis on the beta crystalline form, which is a polymorph form of this imatinib. And this beta crystalline form is of imatinib mesylate. There is a salt form of imatinib, which is salt form is a derivative from the free-base molecule. So when this application was filed, as Justice Bhatt also mentioned, there was side litigation on exclusive marketing rights. In fact, the litigation panned out in two jurisdictions in Madras and in Bombay with contradictory decisions on whether Novartis is entitled for an exclusive marketing right, because there was a requirement in TRIPS. And in fact, India learned it the hard way because we also lost the dispute on non-implementation of exclusive marketing rights and mailbox facility in 1998. But post that, we amended the law and we allowed companies to apply for EMRs and, in the mailbox. So this application, the beta crystalline form of imatinib, was a mailbox application, which was opened in 2005. And subsequently, when examined, the patent office had rejected it, and we all know on what grounds, right? Because the patent office raised one of the major objections, apart from other things, being Section 3D. Now, Justice Bhatt also mentioned that Section 3D's evolution is very different and not very closely aligned with the patent laws, but there is also a regulatory context. In fact, Article 10 of the European Regulatory Directive on drug regulation is the one which the explanation derives its strength from, because all the kind of known substances mentioned in the explanation are from that particular regulation. But it's a drug regulatory regulation, and that's why they evaluate efficacy of a substance to essentially approve the drug for the purposes of marketing. But in India, we introduced it in the context of Section 3D, and this application got hit primarily because in the patent office said that we don't see any efficacy, and rest is history. We know it went to the Madras High Court in a writ petition, and also there was an appeal on the merits of the decision to the IPAP, and then went on to the Supreme Court, and the Supreme Court has given the decision, and we know Justice Bhatt has already wonderfully illustrated what the decision is about. But there are a few things that emerge from this decision, which we are going to discuss in the panel today. There are three major dimensions to this dispute. One is post-Novartis. There are many cases that have been litigated, particularly on what amounts to the disclosure in the genus, or what is claimed in the genus patent, and disclosure in the genus patent vis-a-vis the species patent. There are also issues in relation to how the term efficacy itself might hold a fundamental dimension in assessing these applications. It is important because at that point of time, when the Supreme Court decided this case, in my understanding, the Supreme Court had no other way to justify and give meaning to the term efficacy, because if it did not say therapeutic efficacy or what the drug was intended for, then any other kind of efficacy, including efficacy in relation to hygroscopicity, efficacy in relation to thermostability, which directly do not relate to anything that relates to curing of the disease, would qualify. And then 3D would, in that sense, have been redundant. So to give meaning to this particular, word in the section, the Supreme Court ended up doing what it did. But post that, we have also questions in relation to how the patent office is going to, or has evaluated these standards. What, as Justice Bhatt also mentioned, what kind of evidentiary burden needs to be resolved. And also, at least for those who are located, abroad, one of the questions it raises is some countries would want to follow this kind of a regime. And there are anti-3D kind of provisions that have emerged in free trade agreements and other kinds of agreements. So if there are these kinds of provisions that are being negotiated in FTAs, then it becomes very fundamental to understand the whole contours and what other countries can learn from India, and how this decision has panned out over the period of last 10 years. So that's why it is important for us to discuss also the international dimension, and we have a panelist also to do that. So with this background, I would now we'll stop here, and we will start with the panel. And I would really like to thank Honorable Justice Ravindra Bhatt for being here today, and also Vice Chancellor Bajpai, and also all of you. We'll have another round of good discussions on this case, and I look forward to those. Thank you.
Thank you, sir, for setting the stage for the panel. The inaugural session is hereby concluded. I would like to request Mr. Virender to please escort our guests to join us in the audience. We will now be proceeding with the panel discussion. We will now be proceeding with the panel discussion. I would like to request the panelists to please join us on the stage. We have with us Mr. Hemant Singh, who is the founder and managing partner at Intel Advocare. We also have Dr. Malathi Lakshmi Kumaran, the executive director at Lakshmi Kumaran and Sridharan with us today. We also have with us Mr. Guruswami Natraj, who is the founder of LCGN Advocates. Next, we have with us joining virtually Professor Brian Mercurio, who is currently a professor of law at the Chinese University of Hong Kong. Unfortunately, he couldn't travel to Delhi, but he very kindly agreed to join us online. Before we proceed with the discussion, I would like to take this moment to introduce the moderator for today's session. The panel will be moderated by Mrs. Jayashree Wattal, who is a visiting professor at National Law University, Delhi. Ms. Wattal retired from the Government Procurement and Competition Division of the World Trade Organization in mid-2019, where she had worked for over 18 years and had contributed to work on TRIPS and public health, patents, and various other complex issues. Prior to joining the WTO, she had more than 22 years of experience working with the Indian Administrative Services of the Government of India, and she also represented India at a crucial stage in the Uruguay round TRIPS negotiations from 1989 to 1990, contributing immensely to the development of the text. Ms. Wattal was also a member of the governance board of the Medicines Patent Pool for 6 years. She is the author of an early seminal book that explained TRIPS flexibilities and the co-editor of 3 WTO books and several peer-reviewed journal articles on issues related to the law and economics of intellectual property rights. Thank you, ma'am, for moderating this session. I would now like to request Mrs. Wattal to commence with the panel discussion.
Thank you. Thank you very much, Sanika. And thank you all for being here. Thank you especially to our distinguished panelists. Without further ado, I would like to introduce our first speaker, Mr. Hemant Singh, who actually needs no introduction, especially to this audience, because he is pretty famous. He's the founder of his own law firm, Intel Advocare, and has been in the business of IP litigation for over 35 years. And is actually currently the lead counsel for Novartis. That's just an aside. He is also currently the president of the India Group of International Association for the Protection of IP. So with that, I will give you the floor. Mr. Singh, you have the floor.
Thank you. Thank you, Ms. Wattal, my panelist, Malathi, Mr. Natraj, and the esteemed audience here. It's a privilege to be here on in a discussion which is so important. Not only it was so important 10 years back, but it's going to remain important for next 10 years, because pharmaceutical is going to really be driving the evolution of the patent regime or jurisprudence, you may say, in India. India being the hub of pharmacy of the world, and this constant tussle between the generics and the innovators, which has been going on, a lot of issues are going to emerge. I think we are just looking at a very beginning of several legal battles, because I believe that Novartis judgment raised more questions than it answered. And I may be perceived as being the counsel for Novartis as having a bias, so I will try and speak as objectively as I can. But I believe that the Supreme Court dealt with the issue, which was so critical about Section 3D, and discussed as to what is the threshold for overcoming Section 3D. The judgment did mention that the efficacy for purposes of Section 3D has to be a therapeutic efficacy, but I believe regretfully that it did not really set benchmark or define as to what will constitute therapeutic efficacy and what will not. And that has left a lot of gap in terms of what will constitute or what will not. It surely said that the physiochemical properties of a compound or a new form will not constitute enhanced therapeutic efficacy. But what about, as Justice Bhatt mentioned, what about if there is a efficacy in terms of reducing the toxicity? What happens if there is a improvement in the dosage, and so on and so forth? I mean, I would say that sometime even physicochemical properties, that's my view, physicochemical properties, if it's going to convert a non-therapeutic compound into a therapeutic drug, should be considered as a therapeutic efficacy. Because ultimately, if there is I mean, we all know that it takes large number of failures of new compounds to become a drug. And I'm sure all of you, be IP practitioners or interested stakeholders, it takes $2.5 billion to make one successful drug. The cost of $2.5 billion is not because it's so expensive, but because there's so many failures on which the research and the investment that is made, which goes futile. Because you come out with a new compound, it has a huge potential to treat some disease, but then you find that it is not being, you're not able to develop it as a new drug because it lacks bioavailability, or it lacks solubility, or it may lacking stability or hygroscopicity, whatever you may say. Now, it may be lacking a lot on the physicochemical properties, but if that lack of physical chemical property contributes in not becoming a drug, I don't understand why, if one is able to find a solution to it, it should not be treated as an enhanced therapeutic efficacy. And I hope that at some point of time in a given case, it will be addressed. And I hope that, because I would say that the bottom line, and let's look at things in a very commonsensical manner. You may have the best compound. Suppose you have a compound today which treats cancer, blood cancer, but it is so hygroscopic that you cannot make a drug out of it. And if I, as an inventor, I'm able to find a solution, you mean to say I'm not entitled to patent? To my mind, it makes no sense. Though I'm finding a solution to the physicochemical property. So I would say that we have to look at Novartis' judgment as it existed in 2013. At that point of time, that was the first judgment that was delivered by the Honorable Supreme Court on a Section 3D. It was a very complex issue. The Honorable Supreme Court did a fantastic job of really analyzing it so effectively and coming out with whatever clarity that it could provide at that point of time. But as I said, that was the beginning. We have come down 10 years hence, and a lot of cases, this has been, I mean, in all the matters, me and Mr. Nataraj, we have been fighting each other in court all the time. And he's been giving his interpretation, and I've been giving my interpretation, and the courts have been deciding one way or the other. But a lot of interpretation has been given to the judgment of Novartis, and I think it has evolved. The judgment has evolved. And I believe that a positive fallout of that is that the courts at least have recognized that if there is a new drug which comes into existence pursuant to a new form, then surely a therapeutic efficacy enhancement has been established. And I think that is something which is being consistently, which is being held. We've had this judgment of AstraZeneca versus MCure and the Bristol Myers versus BMS, the two judgments. And of course, we are in the middle of some judgments where the cases where the judgments have been reserved. We are awaiting the outcome as to how the court will look at it. But as I foresee, it's going to evolve. We still have a long way from finding a perfect resolution as to what constitutes enhanced therapeutic efficacy for purposes of drug. And as Justice Bhatt mentioned, there are a lot of questions, and I'm sure that very soon you will find it's going to be Novartis 2 in Supreme Court, which perhaps will give a very, very different perspective and a judgment. And I hope that it will give a very positive message to the industry. India is the manufacturing hub, but why should it be manufacturing pharmacy hub only for generics? Why should it not be the manufacturing hub for the innovator, why that message should not go that your innovation is completely protected here. You are safe to come here. You're safe to manufacture here, and your innovation will be protected. I believe that is the message which has to go. And I hope that in next time when we have a judgment from the Honorable Supreme Court, that's the message which should go. That's what I'll start with. Thank you.
Thank you so much, Hemant. You have started off our panel. You know, that was a fantastic introduction, very provocative, I'm sure, for the other panelists, especially for Natraj. But he gets his turn after a while. First, we have Dr. Malti Lakshmikumaran, who also needs no introduction to this audience. She is the founder and executive director of her own law firm, Lakshmikumaran and Sridharan Attorneys, and she has over 30 years of experience in the fields of biochemistry and molecular biology, and has been a patent agent, and she's going to talk to us from the perspective of her experience with patent filing, and especially in the context of Section 3D. So, Lakshmi, you have the floor.
Ma'am?
Yeah. I can do that. Yeah, thank you, Jayashree.
Apologies, Malti.
I'm not. No problem. I actually thank Yogesh Pai for reaching out and inviting us, also the Vice Chancellor Bajpai. And of course, we had good session from Honorable Justice Ravindra Bhatt. I think Section 3D is quite close to my heart. And as I said, I am a scientist and this is my second profession or career to be a patent agent and do filing, drafting, prosecution of Section 3D. And I just want to continue, he said, Hemant Singh said, he said we should be the hub for manufacturing for innovator companies. What I would say is Section 3D does not allow patenting of improvements of compounds. And if I step back, and we did this so that the innovator companies may not be able to file new improvements of already known drugs and molecules. But today, when I see it in the last 10 years and being practicing, working with a lot of innovators, and especially during the COVID-19 era, where we worked with IITs and institutes and Delhi University, and I had to put my hand up. Sorry, Section 3D, you will not be able to get. It's a new use or a new property, or you're coming out with an improvement, which is a new form. Sorry, or 3I. It was very, very disheartening for me to say that a lot of companies, institutes, scientists do these little innovations. So what my thing is, like what Hemant Singh said is, can we now expand this? I mean, not make it so restrictive. And I see a lot of generic companies not filing improvement patents in India, but filing it in other countries. So it's a little contradiction that in your own country, you will not get, but you can get those grants for those patents in other countries. I think now is the time that the government of India can open up and say, okay, that was that decade from 2005, maybe till 2023 or 25, but now can we open it for the Indian generics? Can we open it for the Indian scientists so the improvement patents can also be allowed? But what I really see is, and Honorable Justice Bhatt already said, that where is the genesis, especially for our Section 3D, which says the Section 3D actually has three parts. It has new form of a known substance, cannot be patentable or will be considered as the same substance unless there's enhancement in the efficacy. The second is new use or new property of a known substance. And the third is new use of a known process. But generally, we always try to. So this new use, new property is something that a lot of our generic companies, scientists can really use it. At least that part can be opened up if not for the new form of a known substance. But if I look back and I look where did it come from, it did come from Article 10B of the EMA, which is a regulatory authority for allowing marketing approval of new drugs. So let us look at a drug. I'm just giving the example of, there they said this very clearly. So explanation, 90% is taken from the section Article 10B. And then in the EMA, it clearly said salt, esters, ethers, isomers, mixtures of isomers, complexes, derivatives of the known substance cannot be granted a regulatory approval unless they significantly differs in the properties with respect to safety and efficacy. So it was properties with respect to efficacy, it didn't say therapeutic efficacy. So, and safety. So like what Hemant Singh said, or Yogesh Pai said, or the Justice Bhatt said, safety is also as important, but we took off that word safety, but we did keep significant properties, that is, properties with respect to efficacy. So let me give you an example. We all take omeprazole, which is a antacid, right? Omeprazole has got two forms, R and S forms, which are isomers. And then we found, will India allow a stereoisomer and S isomer? Yes, it will allow. If the S isomer of omeprazole, which is S-OMES, if it can be more than 50% in your racemic mixture, but it should be more efficacious. If I'm looking at EMA, if it is more efficacious as compared to R&S form, then they will give marketing approval for the S-omeprazole. So India will also do this, that if you can get S-omeprazole, but it must be more therapeutically efficacious. The other thing that they looked at is, and I think when we say we don't have anything on therapeutic efficacy, I think we can look at the EMA and see how it is. So if S-omeprazole, it will not get converted to R. And if S-omeprazole is better than R and it is better than R and S, therapeutic efficacy, then they will give marketing approval for S-omeprazole as a new active substance. There are many such examples that we can have. And therefore, why they didn't allow salt? Because if you have imatinib mesylate, the active substance still remains imatinib. If I have an isomer form or mixtures of isomers, once you administer and you take it in your body, it will come to the same chemical moiety. Therefore, they said we can give marketing approval for this new form of a drug if it doesn't become the same moiety in your body. It should not get converted. So if you have a complex form, the complex should not break down. Instead, the complex should remain as a complex, then it will be considered as a new active substance. Similarly for isomers, similarly for esters. Now in ethers and esters, it is there, it is packaging, but once you take it in your body, the ester and ether break off, but the active moiety remains the same. So in EMA, in the dossier, they have to show that this new form is different in structure and different in the therapeutic efficacy, and it does not become the same therapeutic moiety, and then you will not be able to get. So they like to have this as a new active. So I think that is one of the things that we need to appreciate. And then I can take it on further. Thank you.
That was fascinating, Malti. So, I mean, only she can tell us all these details, which those of us who don't have a science background will not have fully understood. But we know that she knows what she's talking about. So thanks so much for that. So we will come and ask you more questions. I myself have many questions. But before that, let me give the floor to Nataraj. Mr. Nataraj Guruswamy is an alumnus of the first batch of the National Law School, famous National Law School in Bengaluru, and has been a patent attorney for the last 30 years. He is the founder of his own law firm, LCGN Advocates. and he mostly represents generic companies. So we're going to hear a different point of view from Nataraj, from what we heard from Hemant. So you have the floor, Nataraj.
Thank you, Dr. Vatal, Mr. Singh, Dr. Lakshmi. I kind of feel like I'm starring in Spartacus with two legendary heavyweights, and this is a term I do not like using, people who've identified themselves as counsel for innovators. Let me take issue with that. Purely on the question of semantics, I have a problem with the term generic and innovator. Look at the pharmaceutical industry today. Which is the so-called innovator which does not have a generic arm? Did not Pfizer buy Mylan's assets in India and named it Viatris, if I'm not wrong? Does not Novartis have a generic arm, Sandoz, if I'm not wrong? Please, let's leave this generic innovator debate out. As patent owners, sometimes we bust patents for Indian companies. Sometimes we invent. Sometimes we don't. And that applies everywhere across the world. It's not just a NATCO or an MSN or a BDR or a GoFIC, etc., who get sued for infringement. Those who follow the news will, I believe, Moderna sued Pfizer recently. So this really is just a part of the commercial game. So let's leave that semantics, the distinction of innovator and generic out. Turning straight to Novartis. This is the second issue, and I'm going to try and be a little contrarian here, a little provocative here. Novartis is not just about Section 3D. Two key facts that are missed. A, should the Supreme Court have set out guidelines or benchmarks on what is efficacy to the extent that it relates or deals with Section 3D? I say no. It was a special leave petition. It was not a writ petition. It was deciding an inter partes dispute. Certain viewpoints were presented. My very, very dear late friend, Dr. Shamnath Bashir, was there, a man I greatly miss. His views were considered. The Supreme Court interpreted the law. It did not lay down the law, and it carried out its function exactly the way it is supposed to under the Constitution of India in a special leave petition. Point number two, it was not just Novartis which filed a special leave petition. Please read the facts all over again, and the facts of Novartis bear reading and rereading. All the, let me use the term, generics and the NGOs also filed special leave petitions challenging the part of the IPAB order which set aside the controller's order, which had rejected the original patent application on the ground of lack of novelty and lack of obviousness. Please consider this. The Supreme Court upheld those special leave petitions. Therefore, Novartis versus Union of India is not just about 3D. To my mind, Section 3D became the page 3 of the daily newspaper. It was glamorous. That was about it. The judgment bears reading on multiple aspects. It's about what's an invention. What is inventive step? It's about enablement. What is a patent applicant supposed to put in the patent specification if he wants a patent? It's about obviousness. True, Justice Alam does not delineate them topic-wise, but a reading of the judgment makes it abundantly clear that it is in fact the blueprint of the Patents Act 1970 as amended from time to time, being reproduced in the judgment, interpreted in the judgment on each of these aspects. I am an add item there with Mr. Singh, where he says that 2013 Novartis was the first Novartis. There is going to be a second Novartis. Hopefully, and for one reason, why I wouldn't want the law to be settled is because I run an office and I've got to pay salaries. You know, if the law is settled, we are not going to be able to pay people, but that apart, yes, the law needs to change. Perhaps a certain amount of clarity is required. It's not the function of the judgment. It's a function of legislative drafting, the way the act has been worded. A reading of the act, a reading of Novartis, a reading of the history of legislation on the patent side in India show that in fact Novartis deals, like I said, invention, inventive step, anticipation. Why anticipation? The whole discussion on that so-called dichotomy between disclosure and coverage does not have to do with 3D. It is in part enablement, it is in part anticipation. And that is the reason in the third last paragraph, the Supreme Court says,
We are upholding the special leave petition of NATCO, who I represent, by the way, and I was just remarking to Mr. Singh earlier. Ironic that the two counsel who had nothing to do with the original Novartis versus NATCO 2013 are today speaking on Novartis versus NATCO. It has to do with enablement, the duty of candor. Why is that relevant? It has to do with Section 8 and the duty of candor. Why? Because the Supreme Court delves into the history of the original Zimmermann patent, the statements made in that patent, the statements made in the prosecution of that patent. It is very, very convenient today to say, oh, Section 8 is an onerous burden. Forms 27 are an onerous burden. We file 100 patent applications, we get 150 patents. Why should we have to give all of this information? Of course, it's all available on the net. I'm astonished sometimes when these submissions are made. I do not find any of these people quibbling at having to comply with IDS requirements before the USPTO or corresponding requirements before the Australian Patent Office, because they full know that those patent offices will still grant the patent, but the patents obtained in those countries will be worth nothing in an enforcement action. So why do you quibble about a Section 8 in India? Why do you quibble about a working requirement in India? Why do you quibble about a Section 3D here? Again, it's passing strange today, and it's perhaps a function of the 2 years of the pandemic. Today, we talk of India changing its laws, of watering down 3D, of diluting the rigors of a legislation which was crafted for India by India. At the same time, globally, including the so-called developed countries, exactly the same standards are being adopted and applied by courts today. I draw your reference to 3 decisions. Apixaban, pre-trial, the court in Netherlands says, I am not going to give Bristol Myers Squibb and Pfizer an injunction because the species patent is prima facie vulnerable. That resonated. Where had I heard those words before? I heard it first in Justice Bhatt's decision in Roche versus Cipla, 2009. That there is a credible challenge to the validity of the patent. So we are denying an interim injunction, not just that the imposed cost of 80,000 euro. The court in Netherlands. The court in UK, after trial on Apixaban species patent, actually holds it invalid. What's the ground? Implausibility. Identical submissions that were made in India in the Apixaban series of litigations, and I won't comment on that more for 2 reasons. I've been the counsel for some of the winning defendants and counsel for some of the losing defendants in those. But identical submissions made by the patent owners in UK and in India. The UK court says a little known theory called the theory of implausibility, which is a very British way of saying, look, please, now pull the other one. I just don't believe you. We've heard better stories. That's when 2022 May. Netherlands, 2022 April is Apixaban UK, 2022 May is Netherlands, Sweden, of course, went the other way. Equally critically, March, or I think February 2023, the Court of Appeals or the Federal Circuit, the Regents of the University of Minnesota versus Gilead Sciences Inc., Sophos Bovir. Exactly what Novartis in 2013 said on how you need to give data. And when you need to give data, if you want a patent, is what the CIIPC says when? March 2023. Astonishing, isn't it? Those countries haven't lost investments in manufacturing. And I do take issue on that score. Novartis versus Union of India was 2013. Again, this is a bunch of ironies in Novartis versus Union of India. It was given on April 1, 2013. I don't know who was being made a fool of, really. Definitely not Indian pharmaceutical industry. Where I'm coming from is, really, if we are to link in investments in manufacturing in India by patent owners outside India as a function of raising confidence, that's an old chestnut. Because how much of investment in manufacturing in pharmaceuticals in India did they put in before 2013 or before 2009? Bayer did, because Bayer quite literally has been a household name. I fight with Bayer too. for Natco and MSN and others. But Bayer has been a household name for 40 odd years. They do have plants in India. Let me ask this question of all the patent owners outside India who assert patents in India and Indian courts and insist that when they trot in with their patent certificates, they must get an interim injunction. How much have you invested in India before Novartis, before Roche versus Cipla, even before Bishwanath Prasad Radhesham of 1979, in terms of manufacture, not in terms of creating a service industry? Show us the figures, show us the numbers. Did you leave India? Did you close down your manufacturing in India because of Novartis versus Union of India? The answer is no. The only time I remember, and I was a young, very young boy then, when manufacturing industry left India was, I think, 1977, 79 time frame, 79, when we had the socialist part of the preamble being implemented lock, stock, and barrel. And they came back. And let me allay one fear here. None of these companies are ever going to run away from India for one simple reason. They may not consider us a suitable manufacturing base for whatever reason. I've heard an argument being made, not by the pharma industry, I must confess, but by the agrochemical industry based outside India, or we don't make in India because the conditions are not conducive. What conditions? The weather conditions? The traffic conditions? No, we don't know. But we don't make in India because the conditions are not conducive. Here is where I'm just finishing 10 seconds. They will never leave India. They will still patent in India for one reason: 1.3 billion people. We are a market and we fall ill. You fall ill, you buy medicines. You buy medicines, you don't have the money, you beg, borrow, steal, and you buy medicines. 1.3 billion. Let's not forget the power of 1.3 billion. We may never become a manufacturing base for those outside India. I'm not taking Novartis as a name because I don't wish to annoy Mr. Singh, but any of these companies, they will still come here, they will still get the patents here because we buy their products. All we ask, make it a fair price. And for God's sake, respect the law.
Thank you, Nataraj, for being so passionate. Okay. Now we have to go online to Brian, Professor Brian Mercurio. Yeah, hi, Brian. So he's a professor of law at the Chinese University of Hong Kong and is a specialist in the field of international trade, investment law, and particularly in its interaction with intellectual property, including in the context of pharmaceutical patents, on which he's written an article recently. So, Brian, with that, I give you the floor.
Thank you, Jayashree. And of course, I want to thank the Vice Chancellor and Professor Pai for inviting me, the panelists for their great lead up. I'm almost lost for words because so much has been said. I really apologize for not being with you in person. It is not my intention. I managed to lose not only my phone, but also my passport in Singapore about a week ago, a little bit more than that. And I am therefore still in Singapore until I can get a new passport. So unfortunately, I was not able to make my first trip to India, which I was very much looking forward to. My opening comments, I would just say, obviously, this is really a landmark case for numerous reasons, many of which have been pointed out. I will also say it's a landmark case just for exploring the contours and the scope of contextualizing the patentability standards set out in Article 27.1 of TRIPS. It's, of course, also this ruling has an immense impact and effect on patenting practices of, and I am going to use the words, I guess, innovators and generics in India. And of course, the wider impact is then on potentially on innovation and even industrial policy. I mean, there's really no need to go through the case. This has been done. We know the aim, and I think it maybe hasn't been mentioned. The aim, though, is of course of the limitation is I think quite clearly to increase access to medicines by prohibiting the practice of what's referred to as evergreening patents. This can be used and often is used to extend patent protection for maybe minor incremental advances that really serve anti-competitive purposes. This is not all, but of course, when we use the term evergreening, that is what we're referring to, maybe somewhat nefarious even practices. So correspondingly, India obviously is only going to grant protection for pharmaceutical derivatives that enhance the efficacy of the known substance. Now, so we know new forms or use, further use patents, or further use inventions must show enhanced efficacy. Such forms of known substance are then patentable if they, I think the law says, differ significantly in properties with regard to efficacy. I mean, what I find interesting is that the law, of course, doesn't define many terms. So efficacy, what is that? Properties, what is that? Derivatives, what is that? Is not defined in the statute. So it makes sense that the court then had to, lacking legislative guidance, had to, of course, determine which property or properties should differ between a substance and a new form of that substance, and how efficacy is to be demonstrated. What we know, of course, is that Novartis clarified or set out this test of efficacy, or at least the standard. We don't say the test, but the standard, which depends on the function, utility, and purpose of the drug or product under consideration. What's needed, of course, are properties or data, as was mentioned before, that show the new form of the drug has increased that efficacy or ability to treat or cure a particular disease when compared to the existing drug or medicine. That is my maybe simplistic reading of what demonstrating and what enhanced efficacy is. Moreover, the mere demonstration of this bioavailability, right, we heard before, is not sufficient to satisfy the efficacy parameter of Section 3D. So we know again that not all beneficial properties are relevant, but only those that directly relate to therapeutic efficacy. We heard from previous speakers some issues there. So instead, increased bioavailability obviously must lead to that enhancement in efficacy, and be specifically claimed and established by that research data. I think likewise, just looking at some cases, we see, courts in India, and I looked at some Delhi High Court cases in April 2022, the Chugai Sayaku Kubushika Kaisha case, where the court held that the method of producing a solid form, so a tablet of a pre-existing drug via compression method, is not patentable. So again, it's very clear if the data does not show superior therapeutic efficacy, it's not going to overcome 3D. Now, I firmly believe that TRIPS allows for tailoring and contextualization. I argue for contextualization in many, many writings. I don't like how countries just simply copy and paste another's laws without actually contextualizing. In particular, patent linkage, test data protection, etc. So I think in some ways, 3D is a model for this tailoring and contextualization. The question is it unduly narrow? And as Mr. Singh mentioned, and quite eloquently, I mean, I think there's a lot of gray areas. And my problem is, whilst it is certainly valid and appreciative to want to deny evergreening or small incremental, really non-value added advances, to cut out, to not reward that with a patent, to not reward anti-competitive practices. But yet, I don't think the act should serve to deny breakthroughs patent protection. I'm actually not comfortable with this. So my other concern is that sometimes, we do have these great advances which benefit the population without enhancing efficacy in the body. So take, for example, if there's a change in a formula. Now, I'm not saying, okay, you used to take two pills, one 200 milligram, or sorry, two 200 milligram pills. Now you take one 400 milligram. What I mean is a change of formula. Say there is one existing drug which requires refrigeration, has a short shelf life, maybe must be administered by needles, and obviously is going to involve quite a lot of logistics, the ability to have a nurse, clean needles, etc. Now, if that is changed to a stable pill, to just a pill, a temperature stable pill, that's a huge advancement. That is going to save lives. That is going to increase access. This is not evergreening. This is real progress with demonstrable benefits. Such progress should be rewarded with patent protection, in my estimation. So whilst I don't argue against 3D or the concept, I think an unduly narrow interpretation of it to focus on one aspect is actually maybe missing the point of actually having that safeguard in the first place. I think I'll stop there and look forward to discussion.
Thanks, Brian. Yeah, that was very thoughtful. And certainly, I think nobody on this panel would disagree with you there. And in fact, 3D itself probably would, kind of pass muster there. Let us see. So I have now some follow-up questions before we open it to the audience, because I'm sure you have a lot of questions also. But let's just get one round from the panelists, and then we will open out the floor. So with a focus on litigation, let me address our two litigators on this panel here, Mr. Hemant Singh and Mr. Nataraj Guruswamy. Now, we know that in that judgment, in the Novartis judgment, the Supreme Court did say that efficacy is the ability to produce a desired or intended result. That's like a quote. So do you think the Supreme Court could have decided otherwise on the question of efficacy? I mean, even in that case, or in a future Novartis 2, as you said, could this be reopened with this definition of the ability to produce a desired or intended result, given the examples that Brian just gave us of a drug that doesn't require refrigeration, or a vaccine that doesn't require refrigeration, or doesn't require injectables, can be put in a pill and so on. Could that in a future case be decided otherwise? That's one question. Let me give you another question to chew on, both of you, that is Nataraj and Hemant. So with your experience, you kind of, and all panelists referred to some post-Novartis litigation and the outcomes and so on. But could you clearly tell us, in this post-Novartis litigation, has there been legal clarity on efficacy, or has there been more light thrown? What is the relationship between 3D and inventive step? Because a lot of people say, why didn't India just do this through inventive step? Why did they need to have 3D, when they could have maybe even issued guidelines to examiners on inventive step? Why did this happen? So I'll stop there because I have another question, but I think these two are enough. So let me give the floor first to Mr. Hemant Singh. You have the floor.
Thank you. Excellent questions and very, very thought-provoking. You have asked several questions, but I'll try and go in an order. I have, and I'm sure it's very controversial, but I have my serious reservation about Section 3D being there at all. And the reason I believe is that any invention which is patentable has to cross the threshold of patentability, which applies across the board, right? Now, if you look at Section 3D, so far, all litigations have been limited to pharma. Not that Section 3D doesn't apply to others, but why it is not so? Now, is it that it has been incorporated to make it more difficult for patent to be granted for pharmaceutical product because it wasn't permitted earlier? It was only incorporated and permitted by 2005 amendment. So you said, very well, I have an obligation, TRIPS obligation, WTO obligations. So let me do it, but let me make it so difficult that I'm making a lip service that I'm giving you a product patent, but I'll make it so difficult, you'll never get it. That's what has happened to my mind. I am a big critic of 3D, and to my mind, it must be abolished altogether. It doesn't serve any purpose. Number one. Number two, if I have a compound, which is excellent compound to treat a disease, and if that compound is useless because I can't make a drug out of it. Now, whether that could be for the reason of lack of solubility, which has been said as not a criteria for therapeutic efficacy, I ask the question, why not? If that compound is dead like a brick, and if I'm converting it, making it absorbable in the body, and it goes to the target and treats, why not? Similarly, bioavailability. Why bioavailability is not a criteria for therapeutic efficacy? And let me put it on the record very, very clearly. The Supreme Court has nowhere said that increased bioavailability will not be the benchmark for increased therapeutic efficacy. Let's not have any confusion about it. The judgment went against Novartis there because there was no data that was produced by Novartis to show the enhanced therapeutic efficacy, which was caused by the increased bioavailability. Now, naturally, the data wasn't there because Section 3D was being faced for the first time. The application, when it was filed, there was no Section 3D challenges. What is therapeutic efficacy? And all that came later. Now, Novartis didn't have the advantage of producing that data. But the Supreme Court nowhere said that increased bioavailability will not lead to increased therapeutic efficacy. And therefore, in every case where there is a data to show that there is an increased bioavailability leading to increased therapeutic efficacy, 3D has to be obliterated and the patent has to be granted. This can't be an interpretation of the judgment that the bioavailability increase doesn't lead to enhanced therapeutic efficacy. Number two. Number three, the Honorable Supreme Court did a wonderful job, I must say, by defining efficacy as ability to treat the intended disease, right? Now, if that is achieved by any modification in the compound or the state of the art which is known, which leads to increase in the ability of that compound to treat the desired or to serve the desired therapeutic purpose, then that should be good enough. Why there should be exclusions? So I don't understand that. The Honorable Supreme Court nowhere really defined what is therapeutic efficacy, and that is something which the courts are still struggling. And that is where it is going to evolve. And that's where I find that the post-Novartis judgments that have come, as I mentioned, the AstraZeneca and the Bristol-Myers case, where Justice Mukta Gupta made a very, very commonsensical decision to say, look, if there was a compound which has become a drug, then whether it was for the reason A or B or C, there is an enhanced therapeutic efficacy. And Section 3D, therefore, is overcome. Now, that is something which I believe is a very simple formula to be followed. And that's the way I believe that it's going to happen. Now, thirdly, when we talk about evergreening, right, I assume there has to be greening first. I don't understand this argument which is advanced by the generics, and I'm saying generics, yes. To provoke Mr. Natraj, yes. Yes, generics, because what they do is, they will come and argue that, look, there's a dead compound, which I tell them, please go ahead and use it and make a drug out of it, right? But they will not do it. What they will do is, that dead compound, if I've converted into a drug, and it has become a successful drug, Now they want to manufacture it. But they don't want to manufacture that compound. They want to manufacture the drug which I have made. But they say, no, but this drug is not patentable because of section 3D. I don't understand that, right? So the point is that if there is a drug which is coming, then only there is a greening. If there is no drug, and if there was only a compound which had a very high potency, but had no drug development that has taken place, then that is straight away entitled for a patent if it is converted into a drug. The evergreening issue would only arise in the cases where there is a drug. And now I'm claiming further improvement in respect thereof. And I'm, for example, suppose there's a tablet, which is a drug, and now I'm coming out with a polymorph or a new salt, which I say is further improvement upon that. You surely can raise the argument of evergreening, because then I'll have to show enhancement of therapeutic efficacy, which already exists by way of a drug. But no drug versus a drug, I believe, is a non-starter.
Yeah, but I don't think anybody would disagree with you there.
No, but that is something which is being argued.
No, you can't, kind of throw up a straw man and then defeat it. I throw it down and say, like I've done that. So that's something that everybody agrees with. I'm sure Nataraj also agrees with that. We're talking about minor, trivial improvements. And should that be allowed? And would that be caught under inventive step?
Okay.
Do you need 3D because it wouldn't be caught under inventive step and therefore you need the special? That's the question.
No, see, let me answer that. Okay. So 3D only comes in when I have crossed the threshold of the novelty and inventive step. If I have made a trivial modification, right, which if I made a trivial modification, I'm sure that it is novel, because if it is not something which was known, then it is novel, but that doesn't entitle me to the grant of a patent. I still have to cross the threshold of the non-obviousness, right? Now, if it's a trivial modification, if that trivial modification is obvious or not is the test. It is not the triviality of the modification. It's the obviousness or non-obviousness of what I've created. It may be trivial, right? But so that is something which I have to cross that threshold to be patentable. The question is that if I've crossed that threshold of the novelty and the non-obviousness, and I am therefore, then section 3D comes in, and there I have to show that notwithstanding that I have a patentable compound or a drug, right, there is an enhancement in the efficacy or not. Now, there, section 3D requires me to produce data to show the enhancement in the therapeutic efficacy. Surely it's a matter of a data which has to be generated. It must be produced. There's no quarrel about it because section 3D is there. That has to be produced.
But you said it should be abolished.
Well, that was something which was conceptual. I don't think we are discussing that because it is there to stay. That was my personal view, that I don't find, because I believe that any invention which is patentable should be granted a patent, and there should not be an embargo in terms of, this is a pharma. I believe, I mean that's a judgment which has come now of Justice Hari Shankar of Delhi High Court, which says that the controller must carefully examine a patent application, because an innovation is contributing to the state of art. And if it is contributing to the state of art, you have to protect that innovation. So the swing should be to protect any innovation in any field, including drug.
We got it. Very, very good. Thanks so much. So, Nataraj, you have the floor on the same set of questions. Do you want me to repeat it, or you
That's
have?
fine. I'm just taking them as two questions. Number one, why 3D? Why not stick with inventive steps, stroke obviousness? Well, that was the second question. I'll take that up first. And the first question was dead compound, some modification, minor improvement. Why should it not get a patent? Am I correct on the first question?
Not.
I'm just trying to compress the sentence on, given that I overshot my time the last time around.
Not quite, Nataraj. So the first question was more about, since the Novartis judgment itself said efficacy is the ability to produce a desired or intended result, and Brian gave us two examples, just theoretical examples, in addition to Hemal's own example of, a base compound and it's not a drug, can't be used, and so on, which I don't think there's any problem about. But just to say that even within the contours of what we have in 3D and in the light of what the Supreme Court said in Novartis, can we still interpret efficacy in a different way? Could the Supreme Court have done it differently? Will it be done differently in subsequent litigation? That was the first question. Yeah.
I'll take the second one first because that's easiest to answer.
Okay.
The question is, why have 3D when you have inventive step obviousness? As an interesting aside, those familiar with US law would recognize the concept of obviousness. Those familiar with European law would recognize the EPC would know it as inventive step. We're the only jurisdiction in the world that I'm aware of the 180 odd laws that I've read, which uses the two as two separate concepts. We do not have obviousness equals inventive step. Obviousness is a subset of inventive step under Indian law. Now, coming down to the question of why do we need a 3D? The answer is simple. Why not? In fact, I'll ask this question. Given what judges across the world are saying, Brazil, UK, Netherlands, US, Thailand, a set of judgments, all of which implicitly borrow the philosophy of Novartis. My question is simple. Why don't they have a 3D? We need to recognize one thing. It is easy to talk in the isolated silo of the Patents Act without recognizing the fact that the Patents Act has an impact, not just pharmaceuticals. Justice Bhatt identified it correctly, agrochemicals. In fact, the increasing number of litigations are now in agrochemicals. In SEPs, and this is a question that has been put to the division bench of the Delhi High Court, why should we have this strange arrangement for special standard essential patents, forgetting the fundamentals of the Patents Act? Show me the validity. I'm challenging the validity of the patent first, overcome that challenge, then we'll talk royalty, interim royalty. We have an act drafted by Parliament. Are the courts hearing infringement suits or in Novartis versus Union of India, which again I reiterate, was not a writ petition or a PIL, it was a special leave petition between contesting parties on basically an appeal. Should the Supreme Court have gone beyond its powers or its duties in an SLP and started laying down guidelines the way it did in Visakha or the way it did in 377, NAS Foundation? That was not the function of the Supreme Court. Coming back to 3D, why not 3D? It may have come from Article 10B, it may have come from everywhere. For heaven's sake, our constitution is a mishmash of various provisions from across the world. Who hasn't borrowed from who? South Africa proudly says that they have considered our legislations, our constitutions. We should be proud that someone's looking at us and borrowing from us. We should be proud that we have the ability to look at others and borrow the legislations and adapt it to our standards, our needs. That's the second part.
Okay.
First part.
No, but let me just get back to your second part. So are you saying that, you just simply said, why not 3D? But are you saying that 3D is absolutely essential over and above inventive step? Is that what you're saying? And then why? Why?
So here is my reason for this. It is an easy trap to fall into to conflate the potential for rejection or grant of an application by testing it on the anvils of inventive step and say, therefore, we don't need 3D. My answer is this: 3D was not brought in 2005 as an added measure. First of all, it always existed. It was only amended in 2005. It was brought in as an added measure by Parliament, keeping a certain long-term perspective. Now, whether it is in compliance with WTO norms, TRIPS, etc., not my concern today. I believe it is fully compliant. That's my belief. You had novelty, you had inventive step, which had a subset called obviousness. Until and unless we understand exactly how obviousness is interpreted, how inventive step is interpreted and applied in the patent offices or in courts, we cannot simply conflate 3D and inventive step. The two are separate. I'm sorry, I'm using the term again. Two separate silos. The question of what is an inventive step, there are decisions across the world, patent office decisions, court decisions, which test the contribution of a person, that is the inventor, and it's not the amount of contribution. It could have been a small contribution. My favorite example, when I when he used to take sessions at the Nagpur Institute of the Patent Office was this. There's this temple in the south called Sabarimala, which has been in the news for the past 3 years for different sets of reasons, but you need to climb those steps. I'm a tired old man of 53. I reach the 99th step, and at the 100th step, I stop. I can't move 1 inch further. There's a small kid who comes in, holds my hand, and helps me rise that last 100th step, which is just 6 inches high. It's just 6 inches, it's just 1 step, but that's an inventive step. Because I've been sitting for 4 hours, unable to move. It's not the amount of improvement, the increment. It's a question of how much effort went into it. That is inventive step. Section 3D is purely factual. You may be novel, you may be inventive, you may be non-obvious. The lack of patentability criteria in Section 3 has nothing to do with novelty or inventive step. It's a function of a recognition by Parliament of socio-economic conditions in this country or what is needed in this country. And I say this again, we err, and I have erred when I've been prosecuting patent applications when I look at only Section 3. We need to see Section 3 in the context of the whole legislation, particularly Section 83, which sets out exactly why the Patents Act exists. And I urge everyone to see this. 2005 was Section 3D. Please see exactly what Parliament says. 2002 is when 2 critical provisions came into the Patents Act simultaneously. Section 53(4) and Section 107A. 53(4) categorically says there shall be no protection, notwithstanding anything contained in any law for the time being enforced. No protection for a product on the expiry of a patent. Consciously brought in by Parliament. 107A says, without prejudice, etc., development of a product or manufacture, etc., for the purpose of submission of information is not an act of infringement. Please read the legislation and the amendments in sequence in the historical context. We cannot question the Supreme Court here. And we need to see what the Supreme Court does in Novartis. They look at legislative history. They look at parliamentary debates. And they take guidance from that. Because in an SLP, that is all they're supposed to do.
Nobody is finding fault with the Supreme Court.
In the sense of why 3D?
Yeah, no, it's not that. It's not
Only
that at all.
solution, Parliament will have to
Okay, so
amend 3D and remove it.
yeah, you made your point. Okay, let's turn to Malti because
Answer the
I
first
know
question.
that
The first question.
you didn't.
Yeah. So the Supreme Court did its job. Yeah. So I'm just finishing in a minute. Supreme Court did its job in para 157, 158. It says, achieve the intended result. In pharmaceuticals, it's therapeutic efficacy because we're looking at cure. I agree with Mr. Singh completely. And this is an argument we take. It does not say bioavailability enhancement is not efficacy.
Yes.
And this is why I said in my opening remarks, Novartis was an union of India, also about enablement and duty of a patent applicant. It's not about 3D. You want a patent, you want protection, fulfill a law.
Excellent. Excellent. I'm sure, everyone's waiting to ask questions. So we should go quickly. So Malti, I have a question for you. Everyone talked about the data that is required to prove bioavailability and so on. In your experience, what guidance are you getting from the patent office? Are patent examiners actually seeking the data when you are claiming improvement patents and so on? How do you actually prove this? Has anything changed in patent office practice since Novartis, taking into account the guidance given by the Supreme Court in Novartis? So that's my main question to you. In terms of what kind of typical experiences you've had in pre-grant oppositions or even post-grant oppositions, your experience with the patent office. So can you throw light on that?
I'm so happy that, thanks, I'm so happy that, as a controller, sorry, I thought I'm loud, okay. Thank you very much. You know what I have? It's so nice to hear the erring parties, and I'll just put some little fire here. And there is Usha, so I'm going to do that. We've had some very good IPAB orders, and Yogesh has also brought it out in the concept note. The one is a Fresenius Kabi versus Glaxo. That how do you interpret, Section 3D? I'm not going to go into details, but it clearly said that the burden on the opponent or the challenger and I would also take it further, the patent office controllers, is you need to show what is the known substance. How is it that my new form is a derivative of that known substance? So use the explanation to see whether any of those will come. And the third is known efficacy of the known substance. And here we always forget that the therapeutic indication in terms of liver cancer, breast cancer, is it in the same area? Diabetes, is it cancer? We have not looked at those. But what we feel, either the opponents, nowadays opponents, they're really getting very smart, they come up there. But when I look in the last 10 years, the patent office controllers need to learn more and the examiners need to be trained, because many times we just get section 3D objection in view of documents D1 to D4, and there's nothing else. One, we said there are 3 parts. We don't know which part. We assume it's a compound or a composition, so we think it's a new form of a known substance. The second thing we also see is a lot of intermixing between inventor step and section 3D. Oh, you did not show technical advancement because you don't have enhanced efficacy. I think now that the courts are coming, and I'm very happy with the IP division, which is coming out and saying that the controllers have to be very clear in giving the objections and don't mix inventor step and section 3D like that. But if I look at it on the data, there are many. So we as a firm, we did look at 250 different patent applications which had 3D rejections or grants. One of the things we saw is one controller had said, I reject this because D4, section 3D was objected to in view of D4. The applicants were very nice. If I was the applicant or I was the agent, I would have said, what is a known substance? What is a known efficacy? How is it a derivative? But they were nice enough. And they said, yes, yes, yes. D1 or D4 has this molecule. I have modified it because I've made a substitution. But you know, this in chemistry, we all know when you substitute a compound or a moiety in one place, it's a different compound altogether. It's not like in EMA that the moiety, that the therapeutic moiety remains the same. It's a completely different compound. I'm not talking about enantiomers, stereoisomers, but I'm talking of a completely new compound. And that new compound is not the same as the previous compound. But she said, you know, you've given me data. They were nice enough. They gave data. And the word used is, I do not agree how you obtain the data. And it is shadowy. I mean, it's very difficult for us to accept this. Are you a person skilled in the art? And in therapeutic efficacy, it is not done by patent people. It is done by clinicians. It is done in the next step after the patent, after the innovations have been made. So it's very difficult that we don't see these problems. We see a lot of these problems that first and foremost, known substance, known efficacy, how is it a derivative of the known substance? And finally, they should show me therapy. We're not getting that. NCEs are getting rejected under 3D. Many of them. And the pharmacyclics case or other case, I don't want to say. Another thing, I like what Guru said, Natraj said, Martin Guru. He said, oh, first comes novelty, inventive said, so also Hemant Singh, and then comes section 3. Our controllers don't do that. We get section 3 rejection, and therefore I don't have to see novelty, inventive step. Okay, so and then there's a mix of when you get the orders that you've given me all this, but in view of section 2(1)J, section 3D, 3E, I reject the applications. So this is one. The second thing that we've seen is there is a IPAB order, Ajanta versus Allergan, which says a composition having A plus B cannot be objected under section 3D. It can go under section 3E. Because in section 3D, it is a substance, the substance, and one substance. Even after all these years, and Justice Prabhadevan's very good order, some controllers, they'll say, oh, this A plus B, But look at our section 3D explanation. There's a word combination. Combination and derivatives of the known substance. Therefore, this combination should apply to A and B. But when I look back and say, where did it come from, EMA? EMA said that it's a drug. Was it a new form of that drug? So here you're putting A and B. Okay. So this one of the controllers rejected A plus B is a combination according to the explanation of section 3D, and I reject the application. Next comes a second controller and says, one active substance plus active ingredient, pharmaceutical acceptable carrier. It's rejected under 3D. Why? Because 3D is only about one known substance. It is not about two known substances. So it's one known substance, plus you've added a carrier. Therefore, I reject it under section 3D. Then comes another controller and says, oh, it's a composition. And I see Ajanta case versus Allergan, a composition cannot fall under section 3D. So what are we supposed to do as applicants and agents? Do we use the first controller's order? Do we use the second controller's order? Or do we make our own arguments and go ahead? So this is where we are having problem. If what Natraj said or Hemant Singh said, I deal with prosecution, NCEs, new chemical entities, new molecules are rejected under this. Compositions are rejected. Okay, my dear friends, devices and systems are rejected under section 3D. And Natraj clearly said that if you look at the parliamentary debate, it talked about pharmaceutical substance. And if you look at the EMA on that, it is pharmaceutical substance. So we do have, I know we have, but I know, but you know, can I show in a device efficacy and a therapeutic efficacy and show my efficacy? The question here is, show me the efficacy for that. And it's a slag device, okay? Show me that efficacy for that device versus a known device. What is a known device? I don't know. Can you check it, my friends? I leave it to you. So we as fools, before we were doing our own work, this is the closest substance. So you don't tell me what the device is. And I tell you, I got one rejection on a culture system. Oh, it's section 3D. Where? It's a system. It's a product. Therefore, it is section 3D. And so, you know, and I can give hundreds and hundreds of such examples. And this another one is very funny. Under one of the cases, the known substance was D1, okay? But D1 was published after my priority date. So what? I don't care. It's from the same applicant. You should have known that compound because D1 is your application and the present application is your application. So you should know that new molecule. That molecule was already there in D1. So we argue, no, that is published after my priority date. And therefore, we need clarity that when it is not published, the molecule is not known. How can it be considered as the known substance? So what I'm trying to say is, this time we talk of 3D, which is a narrow, restrictive objection that should have been or refusal, but we see it very broad. And I'm not talking on one. I'm looking at 250 cases, out of which just one or two controllers have given very good orders, and they are to be appreciated. But in general, we don't have that. I think I'll stop with this. Yeah.
Yeah, sorry, we are running out of time. So thanks so much, Malti. That was very, very clear. And I'm so glad that Usha is here. And I'm sure she's taken notes of whatever Malti has said. And I'm sure you've been discussing it also. So this has been very useful. Brian, a question for you, follow-up question. You said that you don't think that this is not, this is in violation of TRIPS, section 3D. That's what you said. That's your general view that WTO members. You said it's not in violation. Yeah, that's what you said.
I didn't say that. No.
Well, you said that WTO members are free to define the terms in Article 27 on novelty, inventive step, etc.
Okay.
So basically, 3D is India's way of implementing that article, that provision in the TRIPS agreement, and therefore there shouldn't be any problem in the WTO. Can you answer one question about non-discrimination? There is a clause in Article 27.1 which says that WTO members cannot discriminate with respect to the availability of patents and the enjoyment of patent rights on 3 grounds. One is place of invention, right? 2 is field of technology.
Yep.
And 3 is whether it's imported or locally produced. But the second one, field of technology. So do you think that a provision which for all intents and purposes, as Mr. Hemant Singh rightly pointed out, was really focused on pharmaceuticals? That's the legislative history in the parliament. And even taking into account what Nataraj said, that is not just pharmaceuticals, it's agricultural chemicals. Justice Bhatt also referred to agricultural chemicals. Yeah, it's still a field of technology, which is chemicals. So what do you say to that, Brian?
Sure. I'm going to say as well, I'm still waiting to hear whether an improvement in a change from, say, a vaccine that needed refrigeration and needles to a pill that's easy to take, why that should be denied a patent under 3D. I really just don't see that as good policy. And you can say, oh, that's the law. Sure, but there's bad laws or bad interpretations of laws. So that's just to go back. Something also Malthi said, before I get to your question, Jayashree, you know, when you were speaking, you actually reminded me of the Canadian, the old Canadian judicial made law on utility and what they call the promise doctrine. Now, it had sound beginnings, which is if you want a further patent, a second use, you know, you have to have a sound prediction of what it is going to do. You can't be purely speculative. But as the judges got hold of it, it morphed so that I'll only give one example because of time. The promise written in the patent application by the drafter was that there would be a marked improvement of something. The drug ends up selling millions on the market, fails for not being capable of industrial application, even though it's prescribed by millions of doctors. Why? Because the court said there was an improvement. Yeah, but it wasn't a marked improvement. Therefore, the patent fails for utility. I mean, that I think is ridiculous. And you're looking more at playing word games with what the patent application says, rather than the intent of utility. So a drug being sold, being prescribed, is not actually capable of industrial application under the Patent Act because of one word, marked. It's actually silly. And I think it defeats the purpose of the law, which ended up getting overturned. Now, to move to the question, you're right. It's a very difficult question, actually. Like any great legal issue, it's the subject of disagreement. I think the question comes down to whether this enhancement of known efficacy, in addition to, you know, to the new form or use of a known substance, is consistent with TRIPS, as Jayashree said. And you know, we have the 3 standards of new, inventive step, and capable of industrial application, but also, you rightly pointed out, shall be enjoyable, available and enjoyable without discrimination as to place of invention, field of technology, and whether products are locally or imported, locally produced or imported. The concern, obviously, is that 3D does not allow, I guess, scope for incremental innovation, I should say. It denies patentability when there is novelty or an inventive step, and that it discriminates as to field of technology, right? That's the argument or the concerns. There's the additional argument that it nullifies or impairs a benefit other countries expected to accrue as a result of the Uruguay round. Here, this could be a non-violation claim should those eventually be allowed to run in the TRIPS. Now, okay, so to get to my answer, I suppose, the key terms we know are not defined in TRIPS. So it's my opinion that there is scope for countries to set those parameters. What is new, what is inventive step, what is utility, etc. And we see courts do that all the time. We see courts doing that with the gene patenting, medical diagnostics, business methods. We see courts drawing lines and saying something is not patentable. So that in essence is what's happening here as well. Now, clearly, though, I didn't say that carte blanche, every country can define what they want. There is clearly a line that could be crossed. But what I'm saying is that line is unknown. It's not clear in TRIPS where it is. And until we have a case, we're not sure. 3D potentially straddles that line. On the one hand, you could say it's simply providing guidance, but it is limiting as to, I would say, not only just an inventive step in this, but also what is new in the context of second use patents. As far as discrimination as to field of technology, there's always going to be context-specific examples. And I think if we go back to that Canada pharmaceutical case, which only was the panel, it didn't get appealed, I would draw parallels. And that panel was not so concerned, actually, about the discrimination as to field of technology element. I think, I mean, I should conclude, I think, because of time, but I think, you know, there was serious discussion on bringing a WTO dispute on this case. And in fact, I was involved in several discussions with a lot of Swiss government officials, and Switzerland was very confident of winning this. But what I would ask, and I think their IP department was the voice of reason, I would say, in some sense, and their IP personnel I took my view as well, which is, who else has such a provision? Who else has a 3D-like provision? I think Argentina does now. I think they've copied it. But maybe no, not Argentina? Okay.
Philippines. Argentina has, but it's only in guidelines. South Africa.
Yeah.
South Africa is also a draft, not yet.
Draft, yeah, it's not in. Yeah, so very few. The point is very few. Now, winning would, of course, provide some comfort if someone brought a case and won. Maybe India will comply, maybe not. But, okay, what's the benefit there? Okay, great benefits within India. What about if you lose? What happens if a country brought a case and they're unsuccessful? I will guarantee you what would happen. Many other countries would almost immediately copy India's law. And that would be much greater risk and much greater downside. And we saw that. We saw that with Canada Pharmaceuticals. The EU brings the claim. The EU ends up adopting the same law afterwards, after they lost the case. So did everyone else. So that would happen. And so I think that the legal uncertainty actually may not be such a bad thing, and maybe why we don't see cases on these gray areas.
Thanks. That's a good note to end on, that maybe it's a good thing there's less litigation. Except there would be two people here who would say, no, we would lose our bread and butter. Anyway, so we've got 10 minutes more because we started a little late. So there are a lot of people in the audience, I'm sure, who want to ask questions to our great panelists here. So the floor is open. Yes, please.
Identify yourself.
Okay, I am Sheetal Chopra from Ericsson, but my question is in my personal capacity. That's a disclaimer. So it has been very clear from the panelists, and we've read the legislative history, that 3D is confined to healthcare and pharmaceutical, right? And with the provision that we see in 3D. Now, the problem happens when over the years, we see the larger expansion of 3D to include other sectors as well. For example, in 2021, there was a case in ICT space, communication component antenna versus Mobi antenna tech, where we've seen judge and the lawyers talking about 3D on devices like you also highlighted in the telecom and ICT sector. I mean, it is beyond getting into a digestible mode. Second is in the recent case in if I clearly recall, the very recent case, just a month ago, a few days ago, Chintan Chatterjee, was it Tapas Chatterjee, wherein 3D is being applied to even the process patents. Nowhere is the substance. How do you qualify for Section 3D efficacy for the process? So these are some questions which are now coming up. 3D is not within the confines of its legislative intent. It has started to expand one.
One clarification. Is this in patent office practice or is it in litigation?
The litigation.
In the litigation.
Yes. So that is even more worrisome, right? Just to conclude.
Yeah.
So my final set of two questions. One is, how do we ensure that 3D remains within its confines so that there is a peace and not war in the innovators community and amongst the consumers? We need certainty and predictability. And second is that how do we see, so this question to Nataraj, where he says that IDS in US, and he was trying to equate it at par with Section 8 of Indian patent law, which is foreign filing status. These are two completely separate things. IDS only asks for prior art information as to what is existing in the art. Section 8 is talking about foreign filing status. These are two nowhere linked. So these are my two small questions.
Okay, before we jump in. Any other questions?
Yeah.
Yes. Who wants this? Who said yes?
Kshitij.
Kshitij. Yeah, please introduce yourself.
Yeah, I'm Dr. Kshitij from University of Delhi. I'm faculty there. So what I gathered from the discussion, this is a kind of, you can say, a dilemma which you created through your discussion, I guess, that on one side, we are taking care of one viewpoint, that is inventor's viewpoint, the innovation viewpoint. On the other, we are turning to the accessibility and the legislative mandate and all that. So what I gathered, and I want just some sort of clarity or confirmation that Section 3D in itself is not a cure for anything. As it is, it must be interpreted progressively. It has been held by the Supreme Court also in its judgment. That must be read, that this must not be considered as a general prohibition on incremental drug. And that must be obeyed by the patent office also. So what you highlighted, I am catching that very point, that whether this is a question of administration, patent administration, or it is the question of either existing that very provision, to remain with that very provision, or to get rid of it. So what I think from you is whether, the problem lies somewhere else and we are grabbing and discussing the existence of 3D like it is the main problem. So that's my question.
Your point. So any other question? Last. Yes, Sanika.
I'm Sanika, from a fourth year student from National Law University, Delhi. My question was that Nataraj sir mentioned that 3D is a standard that is above and beyond inventive step, and that you also believe that it is TRIPS compliant. However, as per my understanding of Article 27 of TRIPS, it only mentions 3 criteria, that is novelty, inventive step, and industrial application. And while it does not define these criteria, if you don't interpret Section 3D to be a part of inventive step and above and beyond inventive step, is that not creating a 4th criteria that is not really TRIPS compliant?
Excellent questions, Sanika. All excellent questions. So we don't have much time.
Yeah.
So what I'm going to do is give each of the panelists time to answer any of the questions, the issues that have been raised, and give your final, whatever comments, remarks you want to make to close the panel. Okay, so we'll start in the same order. So Hemant.
I'll try and remember the questions because yeah. So as far as Sheetal, your comment is concerned, I don't think that's a question, that's a comment you have made.
Yeah.
I fully agree with you that the scope and application of Section 3D is really being applied beyond the legislative intent and the objective and the purpose behind its legislation. And that's the role of perhaps the counsel who are appearing to guide the judge correctly, assist him in distinguishing as to where Section 3D would apply and where it has no application. Because unlike like in every case, a defendant always raises all kinds of defenses, and therefore why 3D? If I have 3E, 3F, 3I, I'll raise everything, But it's for the courts to really filter out as to what is the real key issue And I believe that's where, except in cases of pharma or agrochemicals, as my friend Natwad mentioned, you have 3D really become relevant and needs to be adjudicated upon. As far as your question is concerned, I believe that my view was what I said, that 3D is an additional threshold which has to be crossed. If I have satisfied the test of novelty inventive step, still if I don't establish enhanced efficacy, and that is something which has been peculiar, which has been added to India. And that's a comment on the question that you had, Jayashree, as to, is it a discrimination?
Yeah.
You know, as to why when you get a patent all over the world, you don't have to cross that threshold, but when you come to India, you have to cross that threshold. Is it discriminatory to those innovators who have got patent everywhere else, but denied in India? That's my comment. And as far as your comment is concerned, I think you are absolutely right. I may have said that I don't like 3D and it should be removed, but I know it's there to live.
Yeah.
And but since we were discussing it, I said so. But I think going forward, the way is that you have to really understand what is the purpose of 3D. And when you are adjudicating any dispute where 3D applies, you have to keep it in mind that that purpose and objective should not be defeated. A genuine invention should not be denied a patent protection, and the entire analysis and adjudication process and the evidence appreciation should be looked at to arrive at a decision. It should be more of a decision based on the facts and the evidence rather than kind of a bias as to, is it evergreening, not evergreening? No, that's not the way. You should look at the data. If it's there, give it. If it's not there, don't give it.
Good. So Malti, you had few questions on patent office practice that were addressed to you specifically.
Yeah, I think the 3D, I know Nataraj will say that it should go to agrochemicals, but we should understand why it was. It was basically for health, accessibility of medicines to all. And India was a hub for pharma. And that was one of the policy issues, I would say. But we are seeing more and more. I think I just see sometimes now that the IP division comes out with stinkers, should I say, on the controllers. Yesterday you saw, day before, the Dolby matter, the other matters. That I think what I would say is, I don't want to be critical, but I think controllers need to be, or examiners need to be trained. And Justice Prabhadevan also said on legal writing, giving the correct objection, and so that the patentee or the applicant can actually rebut it well. And so also with the opponents, the challengers. I think sometimes we just confuse the whole thing, make a masala, and then give it out. But whereas if it is 2.1J, 2.1J, if it is 3D, 3D. And I really think, especially in 3D, definitely new use, new property should be out. The new use of a known process. Again, I would say an Indian company, generic company, sorry, Nataraj, had more than 20 applications for a process for one drug. Okay. And what I'm trying to say is, you want to actually get that whole field, make a fence, so at all processes, you get the patent for it. But now our 3D, new use of a known process, many times is interpreted. I've had objections. New use for a known process, show me the therapeutic efficacy, which I don't know how can you show efficacy for a process, for producing a product. So there is a lot of confusion. I only would say is that we need objections to be raised correctly. And then more and more the IP division comes and makes it clear, reasoned orders and reasoned objections. It will make our life much easier. That's all that I have to say.
Excellent. Thank you. So Nataraj, especially if you have
Sanika's question.
Yeah, Sanika.
I'll take Sanika's question first. My specific statement was novelty, inventive step, and 3D is about that.
Yeah.
I would still say STRIPS compliant. 27.1, if memory serves me right, begins with invention, the right to define an invention. Section 3 has a title, what are not inventions? Well,
But it's
The-
like any invention, no? Like,
I know.
word used-
See, if you ask me, Yogesh, if you ask me this app would do with a major rewrite, not to delete 3D, I certainly not to delete 3D, but certainly to put it in plain, simple English. What Dr. Sampath, who taught me drafting cleaning, called the American term is KISS, the KISS rule. Keep it simple, stupid, right? Keep the law simple. You'll have less work for lawyers. That's number one. So term invention, I'm allowed to define as India. Second, every country of the world has what is certain criteria of certain categories of what is not patentable. I'm leaving that answer there. Coming back to what Ms. Chopra said, I happen to be part of the team that's working. Oh, she's not here. Is she
She's
here?
not here, she's left.
Okay. So anyway, I'll just answer it for
But the
the
other-
rest who are
yeah,
here.
the others are listening.
I happen to be involved with the people who are arguing the communication components versus movie antenna case. It's a fallacy to assume that in or the Tapa strategy case, I'm not involved, but I've watched those arguments. At no point in the court did any counsel make a statement that a device has to have efficacy or that a process has to have efficacy. Please let us understand this very, very clearly. 3D is not a new invention which has been included in the Patents Act. Mere new use of a known process, mere use of a device, that part existed from 1970. Communication components was in the use of a device on that aspect of 3D which has existed, well, slightly before I was born. Likewise on the question of process. The question in court was not on efficacy. I am with Dr. Lakshmi Kumran here when she says, yes, in the patent office, sometimes these objections are raised, and I mean no offense, ma'am. Sometimes objection is raised, shows the efficacy in the process. It is difficult to answer. The first instinct is to giggle. When you say, look, what do you do? So you put an argument in. That is a problem. Perhaps I would be completely on the same wavelength or ad item or whatever. You see, yes, there has to be training right down the line. Last question on section 8 and ideas since this question has been asked by Ms. Chopra. There is no difference. I have prosecuted patent applications in 80 odd countries or given instructions to prosecute them for 80 odd countries for over 16 years. Frankly, I've acted as a post office in India for clients outside India. I've acted as a postman or the post office, the head post office here when giving instructions abroad. I've always found it amusing when a US attorney writes enclosing an office action reminding me of an IDS requirement saying, please give copies of examination reports and all citations raised therein. Because that's exactly what I tell them when they report an Indian examination report. It's as simple as that.
Okay.
Yeah.
Thanks. Thanks.
Just one last note, perhaps. Perhaps given that we are talking of evergreening, and sorry, I'm notorious for my puns, we just need to conifer all over again. I know I'm bad at this, but I've been thinking of this for 10 minutes. I had to say it.
Okay, evergreens. Okay. So Brian, are you still with us?
I am.
So Brian, could you answer Sanika's question? Attempt again, once again, because what she says is TRIPS says there are 3 criteria in Article 27.1. If a WTO member adds another criteria and keeps on adding, you can keep on adding, then is there no limit to how many criteria you can add? Or if you add a 4th criteria, you're actually making sure that less and less inventions get patented, and therefore it's a problem with TRIPS.
Sure. I mean, you obviously didn't get the hint that I didn't want to answer that question. that I just straddled both sides. I wonder if as well it's a matter of phrasing, because if you actually say that it is just a matter of that it is part of what is an inventive step. It's not a 4th criteria, it's just part of the inventive step. Then in fact, it's just putting parameters on that, which is what we do all the time. What is new? What is inventive? This is what courts do. If you do add it and say, well, it's, there are 3 listed, plus we're putting another, and plus we're not going to, I don't know, take applications from countries that begin with C and things like that. Obviously, you're running into problems. So I think it's actually more advantageous to simply say it's a limitation of inventive step. And again, on that discrimination point, it's really tough because in some ways, actually, the pharmaceutical industry, when we look at like utility, particularly for second use, is treated better in most countries. And courts in many countries have simply said, look, we cannot know what exactly this drug is going to do because, you know, phase 2 and phase 3 trials have not been conducted. Patents are filed much sooner. We cannot, this is how it works. We cannot have them tell us exactly what the utility of this product is. That's unique to pharmaceuticals, agrochemicals, et cetera, as well. But in fact, more preferential treatment. But I do see the discrimination argument. I wanted to just conclude with one thing because I know Yogesh wanted me to mention it, which is the future of this. Where do we see it going? And it is my you know, and your area too, Jayashree, of the intersection of trade and IP, and it's in free trade agreements. I mean, what is the reaction been? And we see the reaction quite a lot to attempts to narrow constraints or attempts to widen compulsory licensing, etc. We always see a pushback in FTAs. So countries say, no, you can only issue a compulsory license under these circumstances or what have you. And we see that here too. So, I mean, since Novartis, we've seen the US attempt to include a provision which would, which essentially would require the patenting of the new uses of known products, etc. We see that in the TPP and in the NAFTA 2.0, the US Mexico-Canada agreement. However, in both instances, those are not in place. One, because the US withdrew from the TPP, and in the CPTPP, that provision is one of the suspended ones. And second, to get the USMCA over the line, that provision was one that was removed by the protocol of amendment. I wouldn't take too much comfort in that, though. I mean, remember, the Democrats pulled back on pharmaceutical provisions in FTAs with Colombia, Panama, and Peru, but under Obama. But then under Obama and the TPP, they were back, right? So just because there is a temporary reprieve, I wouldn't say that it's going to be forever. It seems a certainty, I think, that such clauses are going to return in the future. Interestingly enough, in a leaked, UK-India FTA draft, which is quite clearly drafted by the UK, there is a provision which would reverse 3D as well. Obviously, India is not going to agree to that provision. I mean, so I think what I would conclude by is saying there's regulatory autonomy to prevent evergreening. That is allowed under TRIPS. I think that can occur by narrowing the scope of patentability. We see that with Canada utility. We see that with India and 3D. But there's other means as well. I mean, I would point to Korea and Australia by, for instance, conditioning injunctive relief. Rights that they preserved in free trade agreements with the US. That's the key, right? Preserve the rights, preserve the policy space to act, and try not to bind yourself when it's not in your interest to do so. So I think I'll conclude there. And this has been a fascinating panel. I'm really quite honored to have taken part in it. And I really wish that I could have been.
So with that, thank you so much, Brian. And especially given the late hour in Singapore, thank you for remaining with us. And all of you, thank you so much to our distinguished panelists. Mr. Hemant Singh, please accept a token of NLUD's appreciation. Thank you. Dr. Malpi, thank you very much for being part of this panel. Thank you. Natraj. Thank you. And thank you all for being patient because we've run very much past.
And Brian, tell me when you visit us next.
Thank you.
So let us know when you're visiting.
Thank you. Thank you all for remaining here despite the late hour. And I wish you all a good evening. Thank you very much.
Thank you.